Thank you, St. Louis, and I thank you, Chairman. So just a few weeks ago on Juneteenth, I introduced into the congressional record a document to commemorate the unveiling of the Freedom Suits Memorial Monument. The Freedom Suits Memorial paid tribute to the hundreds of cases in which enslaved Black people filed for their freedom from bondage in federal courts in St. Louis. The most famous case was that of Dred Scott, in which the court held that Black people had no rights which the white man was bound to respect. Dred Scott is buried in St. Louis, in my district, and his legacy serves as a reminder of the dangers in believing that the Supreme Court has always been a just body. It has not. Substantive due process itself was birthed in the aftermath of the Civil War. It was not legal doctrine that led to the Emancipation Proclamation. It was not the court. It was not the Constitution, which was written to guarantee the rights of land-holding white men. It was not moral righteousness that led to the Emancipation Proclamation or the emancipation of Black people. It was violence. It was war. It was the resistance and the persistence of abolitionists that put an end to chattel slavery. And it was because of our freedom dreams that the collective dreams of Black people, past and present, who demanded to live in a world free of bondage. It is not lost on me as a descendant of enslaved people and as the first Black Congresswoman from the state of Missouri that my existence in this space alone is a testament to the freedoms denied by the Supreme Court of the United States in its Dred Scott decision 165 years ago. Professor Murray, footnote 41 of the majority opinion in Dobbs makes a eugenics argument on the impact of abortion in Black communities. Can you explain the significance of footnote 41 as it relates to contraception?
Sure. To coin a term used by Representative Owens, you might view this as a kind of condescending racism, the court attempting to link the history of the modern birth control movement and reproductive rights to the history of eugenics for the purpose of essentially arguing that reproductive rights are rooted in a history of racial injustice. I believe that this footnote doesn't really bear on the logic of the Dobbs opinion, but rather is there to seed an opening for eventually overruling the right to contraception on the ground that it is a racial injustice. The idea being that Margaret Sanger, through her work with the eugenics movement, was essentially trafficking in racial injustice. And for that reason, the right to contraception should be overruled as a means of remedying that racial injustice. It is the most craven form of racial condescension, in part because it is being parroted by those who do nothing to assist the Black community, whether in their judicial opinions or in their actions and other beings.
Thank you. Another question for you, Professor Murray. The Reconstruction Amendments were drafted not only to eradicate slavery, but also to eradicate the vestiges of slavery and all forms of bondage. The drafters wanted to go farther than making Black people citizens and wanted to guarantee a sense of liberty. Can you talk about how the drafters defined or understood liberty when drafting the 13th and 14th Amendment?
Yeah, so if the 13th Amendment abolished slavery and the 15th Amendment gave Black men the right to vote, the 14th Amendment was primarily concerned with eradicating all of the indicia of slavery, the very things that distinguish slavery from freedom, among them the absence of bodily autonomy and control over procreation. And this was very clear. They knew about forced birth as a means of expanding the slave population in the period before the Civil War. So they were responding to this. They also wanted to correct the injustice of having no family integrity, of lacking control over your children, of being ineligible for civil marriage. So in that grant of liberty in the 14th Amendment precedes all of these rights that had been denied to the enslaved and were now given to them. They weren't explicit because they were viewed to be captured in that grant of liberty. Justice Alito says nothing about this. It is a selective and itinerant commitment to originalism that his opinion evinces.
Thank you. Thank you, Professor Murray. As has been noted, this is the first time the court has taken away a fundamental right. It is important to note that our most fundamental rights have never been safe, and they never will be guaranteed so long as they depend on the ideological whim of 9 unaccountable, unelected justices with lifetime appointments. It is why we need to limit the power of justices by expanding the court, instituting term limits, enacting a code of ethics, and it reinforces why Congress should strip the court of the right to take away fundamental rights. Thank you, and I yield back.